Ladies and gents, this is all I say. Oh, what a night. As tired as I am, and I am running on fumes, but I gotta do this video. If I didn't do any other video, this video is more important than the other ones I talked about getting people out of jail. Let me talk to you. Y'all wanted to hear what type of night this is? Ladies and gentlemen, do you remember I did the video telling you about the guy who got, pay attention, 412 people freed from jail for owing child support because he filed their court cases in bankruptcy court. Now remember, I told you I could care less about that person, but then somebody had to speak up and say that I had misguided y'all. Ladies and gentlemen, this is the First Circuit Court of Appeals, a very stupid and ignorant court. The head judge is Lynch, and she's a, I'm sorry. Anyway, we're going to continue before I talk about these morons at the First Circuit, and that's what I said. They're a group of idiots. Look, again, let me show you how they're making it seem like they are angry and saying something is wrong when it ain't wrong. I want you to follow me, okay? I want y'all to pay attention. This is Valentin, Valdez, Alea, okay? Notice, appeal from the United States District of Puerto Rico. Hey, Ada Delgado Colon, now that's a hoe. I'm going to say it out loud. That's a slut, okay? Ada Delgado Colon, she was the head judge. I don't know who she is now. She's a hoe, okay? She can hear me say it. I'll say it to her face, on the record, without missing a beat. I'll even take contempt of court charges for that hoe. Sorry. I apologize, y'all. I didn't expect to see her name there, because she's anyway, we're going to go on, okay? Oh, there's Howard. This is Lynch. This is, that Sandra Lynch. Howard. I said Lynch. I'm sorry. I knew somebody by the name of Lynch. Howard Lynch. And so I don't mean Howard Lynch. I mean Sandra Lynch. Or whatever anyway, and Thompson, they work together all the time making decisions. But let me show you what these idiots did, okay? You guys are going to love this. I don't know these people right here. Well, we know who she is. We know her. She's an idiot too. Okay, I don't know the rest of them, but I know everybody else I just mentioned. Okay, now this was on the 15th of August, 2018. Let's read this. Now this is Judge Thompson. Like I said, he's a moron. At the least, at the last 8 years. For at least 8 years, the defendant, Valentin, and I'm going to mess up some words because I am tired. I can almost barely see the screen. I really am exhausted. I'm not making it up. It's the truth. But this video is important. If you got people who are incarcerated, you're going to need to pay attention to what is going on here. We're not going to read the whole thing because this thing is how many pages? 58. We ain't gonna read no 58. What the? They ain't gonna read no 58. I promise you, I ain't gonna read no. I ain't even getting close to 5 pages. Anyway, we're just gonna refer to him as Valentin. Okay? Mr. Valentin exploited the desperation of individuals who were behind in their court-ordered child support payments. He did so by illusionary promises of professional legal assistance in exchange for approximately $1,575 and then filing incomplete petitions in bankruptcy court to secure the stay on the Commonwealth of Puerto Rico's collection efforts. Eventually, Valdez's scheme attracted the attention of federal law enforcement officials which led to his trial and conviction on several fraud-related offenses. Pay attention, ladies and gentlemen. Remember, they're saying that he committed fraud. He didn't mislead anybody. He didn't misrepresent anything. Nobody relied on his misrepresentation to their injury. Nobody was injured as a result of whatever they claim his misrepresentation is, and I promise you, I guarantee you, they did not prove fraud in his case. I'll prove to you they didn't prove fraud in his case. Let's continue. Like I said, they're covering that part up, but remember, you accused of fraud, they got to prove all elements of fraud or there's no conviction. So let's take a look at what goes on here. Gotta clean my glasses, y'all, because I gotta see, and I'm having a real hard time. I really am having a hard time seeing. I'm that tired, and that's what happens when I get tired. Eventually, Valdez's, Mr. Valentin's scheme attracted the attention of federal law enforcement, which led to his trial and conviction on several fraud-related cases. The appeal he makes, bringing several claims of trial and sentencing errors. For reasons discussed herein, pay attention, we affirm his conviction and the order of restitution imposed, but vacate his sentence of incarceration and remand it back to the district court. Wait a minute, for resentencing. Wait a minute, hold on. You affirm his conviction, you say, okay, he's guilty, but then you agreed that the sentencing that was imposed upon him was an error? And now you're going to send him back to the court on remand to be resentenced so he can appeal all over again? Interesting. I wonder how often they do stupid things like that. Interesting, huh? Now see, in my case, I need you guys to understand, they didn't affirm the sentence, they actually overturned it. And then they ordered resentencing on the charge of the driving without a license because the attorney didn't bring up the driving without a license, and I'm bringing the charge of driving without a license. I'm bringing it up. But he didn't bring up that charge. Ladies and gentlemen, okay, let me tell you how hectic today's been, and I'm going to finish this video. There was a young lady, I did a consult with her last week. And we had a continuation of that consult because they get an extra 30 minutes, and that was today. I spent an hour with her on the phone, on video, communicating, answering all the questions she had, because with me you get more than what you paid for, and she paid for 2 consults, so she gets another one in the future. So that's just to let you guys know what's going on. And I'm not going to say her name, but very, 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 very pleasant individual. I'm being honest. I respect her highly. Okay? And no, I'm not kissing up. I'm just letting you know. Because I told her I was going to send a copy of the audio of our recording, because I record the sessions and I send it to people so that they don't have to take notes. They can just go back over the information. Well, I forgot to send it to her last week. I thought I did. I literally did hit send, but my computer has no record of me sending it. So I had to locate her file again, and I sent it to her again. Okay, follow me. Today, she told me that she never got it, and I said, okay, I'll get that to you today. And then I forgot, because I got hit by a ton of other things today, ladies and gentlemen, including this stuff right here that we're talking about, and all the things going on with the company and so forth. And again, I am looking to have less than 15 days to take care of things. So, sorry. A lot of stress, but we're okay. So she texted me tonight and said she still hadn't received it, and I apologized to her profusely because I really did forget. And I told her I will take care of it, and I took care of it at that moment. I wanted to lay down and get ready to go to sleep, and I have to do some research for where I'm going to be going. And I haven't done that. But then I came across this because I had downloaded this earlier today, and I started reading just this part. And I said, I got to do this video and let these people know what happened in this case. Ladies and gentlemen, I was able to get her a copy of the recordings, but there was another gentleman who, on the same day of last week that I did the consult, that we were supposed to talk today at 1 o'clock. My time, 4 o'clock his time. But in my mind, I'm thinking 4 o'clock, but then there's a problem because we have our meetings on Thursdays at 4 o'clock. And so I confused the two. Sorry, I can't blame it all on COVID. Okay, but I can say that I was overwhelmed today with a lot of things going on. I also have a person who is incarcerated, been in for 29 years, that I'm doing an arbitration motion to confirm to the court, and I have to add some things in there to help him out if the court ignores his request, so that if he goes on appeal, he'll have an argument on appeal. So I had to, amend the normal motion to confirm and do an incarceration motion to confirm. Eventually I'll put it out there for the people who got people incarcerated and doing the motion to confirm for the incarceration contract. As I spoke with an older gentleman this evening who called me, he was asking about his incarceration contract. Apparently they put him through some things, and he was asking me, should he go ahead and redo the arbitration, or should he just, well, I told him no. I said, why? Right now, give us time to go to the appeals court and get this resolved. But for right now, go after your tax credits. All of you who've had the courts deny your arbitration, by all means, you should be going to court doing the summary motion to confirm. It's a summary motion. It is not a lawsuit. You don't have to pay $500. You don't have to pay $450. It's $47 to get a motion to confirm. It's a summary proceeding. Okay, there's too much case law on that. It's not a litigation. So $400, $500, that's litigation. A confirmation is not litigation. So don't let them charge you $400. Tell them, show me in the law where I got to pay $400 for a motion to confirm. Tell them you better go look at Federal Rule 81, Section B. Okay, other than that, I don't want to hear it. You can shut up and get on my face. Shoot, you gonna file my in here today? No, sorry. Okay, so yes, today's been a hectic day, and I was trying to get myself to lay down early so that I could make it through tomorrow, but it don't look like that's gonna happen. Okay, then I found this where the appeals court, now I want you guys to pay attention because you may not understand what's going on here. The appeals court claims that they affirmed his conviction and order of restitution, but they vacate the sentence of incarceration and remand it to the district court for resentencing. Look, pay attention. They vacate the sentence of incarceration, saying that he should not have been incarcerated. Wait, why would they vacate the sentence of incarceration? Well, let's go to the end, because we don't need to look at the background, because, oh, and by the way, child support collection in Puerto Rico. In Puerto Rico, the Administración para el Subtiempo de Menores, or Asume. A lot of commercials about Asume. Governs child support determination, modification, collections, and distributions. When the Commonwealth Trial Court ordered a non-custodial parent to pay child support, Asume is responsible for collecting the payment and sending it on to the custodial parent. No, they did not. They did not say that. Look at what the prosecution said. It goes to the beneficiaries of child support. Who are the beneficiaries? It ain't the custodial parent, because the custodial parent doesn't get the money for child support. It's supposed to go to the child. But that's not what happens, is it? Okay. It says they have collection tools at their disposal when a non-custodial parent misses a scheduled payment, including retention of income tax funds, withholding of income, suspension of sports and professional driver's licenses, and referral to credit agencies. Interesting. Look at that. Look at all they get to do. This is an interesting thing for us to be going over, y'all. But what you guys need to understand is what's going on here. Because Valdez challenges sufficiency of the evidence to support some of his convictions, we will relay the facts of the case in the light of the most compatible with the jury's verdict. Ladies and gentlemen, he's challenging several aspects of the conviction and the evidence that they introduced, and they said, no, we're going to deal with what the jury said. Really? He's talking about evidence and how y'all got about and did what y'all did, and y'all just going to say we're going to focus on the jury? Anyway, basically they overturned the jury's verdict and ordered resentencing. So you're going to find that more than likely they're going to resentence him to probation. I don't know what they sentenced him to. I haven't looked at his case. This was 2018. It's now 2020. Okay? And Valentin, even if somebody tells you about this video, no, I don't want to talk to you. Sorry. I tried to tell him then, and he didn't listen. The same as all of you. If I try to help you, and you don't listen to me, ITYS. I told you so. But no, it's not about forgiving, because I don't have anything against the person. He went through all of this because he wouldn't listen, and he got what he deserved for not listening. Okay? All right. Shall we go on? We don't care about none of this. We're going to go all the way through. You know, there's an easier way to do it than just using your finger to do it. I don't know what you're doing. Wait. The preparer cannot take the required credit counseling course on the debtor's behalf. The really big yes, the petition preparer must sign several parts of the petition, attesting that he or she has adhered to the various requirements of bankruptcy. Ladies and gentlemen, understand, it's not Valentin's responsibility to take those tests. It's not his responsibility to tell this to the other party. It's the other party's responsibility to read the paperwork they receive from the court, because all of the bankruptcy courts give you the papers, tell you what you need to do. Okay, he was charging the people $1,500. I was upset with him. If they can't pay their child support, what the you think they're going to pay $1,500 to you for? And I'm not joking. That was my argument with him. He was greedy. Okay? Guarantee of the right of the accused to be informed of the nature of the cause of the accusation. Interesting. So apparently there is something going on here. One of the principles embodied in the Sixth Amendment is to guarantee the right of the accused to be informed, okay, whether the indictment as a whole conveyed sufficient information to properly identify the conduct relied upon by the grand jury is proffered, think the charge, without sufficient information to identify the conduct which the grand jury has deemed adequate to support the indictment, an accused is at a material disadvantage in meeting the charge Why would I want to meet the charge? A constructive amendment occurs when the charging terms of the indictment are altered, either literally or in effect, by prosecution or the court after the grand jury has last passed upon them. In other words, apparently they altered something. They changed the charge because they knew that they could not get a conviction based upon the way they were trying to charge him. Okay, that makes sense. I guess he had a pretty good attorney then. He finally got an attorney who was worthwhile, because he definitely couldn't handle that himself. And that argument was a good argument. Okay. His argument was that bankruptcy court is not a victim for restitution as defined in both that's his attorney doing that. And I agree with that. The bankruptcy court didn't suffer any injury. The bankruptcy court cannot sit up there and claim to be a victim. Discretionary statute fares no better. For the purposes of restitution, victim is defined as follows: a person directly or approximately harmed as a result of the commission of an offense for which restitution may be ordered, including, in the case of an offense that involves the element of a scheme, conspiracy, or pattern of criminal activity, any person directly harmed by the defendant's criminal conduct in the course of the scheme, conspiracy, or pattern. Do you know what we realize, ladies and gentlemen? That all of the people who are in jail who pay restitution, they take it from the monies their families send in. So when you're sending money to your relative, the courts are taking that money. They're taking at least half of it in California. Here's the problem. Like in my case, they took $2,400 when the restitution was only $1,200. They took $2,400 plus another $500 plus another $500 for the people who were doing the consults. They never gave me those monies. Now, when I went to the county office, say, hey guys, I need to get my refund. Let me get the paper so I can fill it out so I can get my money. They didn't know what I was talking about. They said they checked the system. No money had ever been turned into them as required by law. So the prison kept the money. You must understand, the money never gets to the family members, never gets to the victims. When people pay restitution, the victims never get a dime. Go back and check. All of these inmates who are in jail, who are paying all these restitutions, it's not getting to the victim, it's going to a general fund, people. This is the game that they play. Okay, says details of the ways in which the bankruptcy court was directly or approximately harmed by Valdel's fraudulent use of the bankruptcy system to perpetrate his scheme. The harm stems from the waste of the court's already scarce resources to process the skeletal petitions filed on the sole purpose of taking advantage of the automatic freeze of their collection activities that he knew the petitions would generate. That means he used the bankruptcy laws to his advantage. So, ladies and gentlemen, we all know that the individuals had a right. If the courts of the state or the island of Puerto Rico was overcharging the parent, who they said was back on his payments, and it was causing him distress financially, he has a right to petition for bankruptcy. So no fraud there. They're using the system because the system has a mechanism for them to use it. Okay, let's see if we can go on. I'm trying to get to the end of this. These people are taking so long getting there, just like you do all the time, you ignorant of your mama. Okay, therefore, this case is distinguishable from Gibbons, relied upon by Valdez, because the bankruptcy court incurred losses in the ordinary course of managing its operations and not, as Valdez contends, during a discreet investigation into his misuse of the bankruptcy system. See, notice this. This is what his attorney said. His attorney said his misuse of the bankruptcy system. So he's admitting he did something wrong. That's language of the attorney. Okay, that's why if an attorney's going to represent you on appeal, you tell him before you file anything, I want to approve it. Just that simple. You don't get to file nothing without my approval. I don't give a who they tell you is. Anyway, the government agency may not recoup money lost as a consequence of a crime via a restitution order pursuant to Victim or Witness Protection Act when losses incurred by an undercover investigation provoked by the commission of a crime at issue. That's what they relied upon. Finally, his claim that the affirming of the order of restitution will allow the court to collect twice on his fines is completely without merit. First, there is no suggestion that the government has attempted to enforce the collection of the fines through the bankruptcy court cases. Second, once Valdez pays his restitution, he may move to reopen any of the bankruptcy cases in which the fine has been imposed and request the court to enter an order staying the fines that have been satisfied. No, he's absolutely right. Ladies and gentlemen, what they did is the bankruptcy court fined him. After the investigation, they fined him at the bankruptcy court, and then they fined him in the criminal case. So he received 2 fines for the same crimes. Okay, that's double jeopardy. Okay, it's just that simple, and I don't give up what these people say. A case may be reopened in a court in which such case, guess what, ladies and gentlemen? The case may be closed, but the fines were still imposed. So now he has 2 fines from the same crime imposed on him at the same time. One has to give way or they both go away. The attorney knows that, and these idiots know that. And to that end, the government contention that because the underlying bankruptcy cases are closed, exactly final, the only way it will be able to collect the unpaid fines is through enforcement of restitution order is also not accurate. But be that as it may. What do you mean be that as it may? The government says we want to get our money and we can't get it because those cases are closed. Look, all of the bankruptcy cases are closed. The people are not in jail anymore. All of the cases are closed. Why? Because the scheme was, we'll get you out of jail. If you want to go through a bankruptcy, you go through a bankruptcy. If you don't want to go, let it die. The judge is going to give you different terms to pay, and then you take care of it from there. I know that's what he was doing. Okay? There was nothing illegal about that at all. Bellows has therefore not shown that the district court committed any error, never mind a clear or obvious one, when it ordered restitution to the clerk of the court for the district court. Conclusion: to sum everything up, we affirm Valdez's convictions and the order of restitution, but vacate his term of incarceration and remand for resentencing using the proper versions of the guidelines manual. That's it. Literally, that's how they end it. That's bull right there. But, ladies and gentlemen, as I said, they went after him because he was messing with their money. That's why you see they want to hit him for restitution. He's worried about paying back restitution. He doesn't. He file in bankruptcy and gets rid of it. Lord have mercy. He's been doing bankruptcy. Why not continue with bankruptcy? Ladies and gentlemen, I'm doing this video to help you all see that this man did not go to jail because he helped 412 people get child support recalculated and get out of jail. Pay attention. I'm doing this video so you can see that he got people released from jail. They were ordered to jail by the court. He got them released from jail by filing their cases in bankruptcy. Okay, we all knew about this. We were all told to take your case and file it in a bankruptcy. We've been doing that. We were talking about that in 2012. So when in 2014, well, actually 13, when I heard the case on the news in Puerto Rico, I said, I know exactly what he's doing. So this is what we were telling people to do. Okay, and I promise you, this guy doesn't even know what he's doing. I knew because it was federal, he was going to come to the facility we were in. I didn't know he was going to come to my section of the facility. It just so happens when they got mad at me for helping so many people, they put me in lockdown. Okay, when they put me in lockdown, he ended up being my cellie. That's how I got to talk to this idiot. Okay, so ladies and gentlemen, the process for getting people out of jail is not like his. You're not committing a scheme. The person owes a debt to society. Am I right or am I wrong? Is that not what they say? Well, if he owes a debt to society, and according to the Treasury, there is no money. Well, if there's no money, then guess what? Then he can't pay. That means he's destitute. Dragon, naturally speaking, is updating. So they said they have an update, and I'm glad they got an update because I need that program so I can finish my motions. So, ladies and gentlemen, that's all I'm trying to tell you guys. It worked. And notice they vacated his term of incarceration. They vacated it. Now, can they give him, I want you all to pay attention. They can give him another term of incarceration. It's not double jeopardy. But you know what they can't do? They can't give him an aggravated sentence or a higher sentence or a sentence equal to what they gave him. It has to be less. And in this case, because it was vacated and they said that the court did not follow the guidelines, see, the proper version of the guidelines, the court was angry at him because he pissed that hoe off. I'm sorry, she is a hoe. I'm sorry. Whew, Ada Delgado Colon. And I met her son. He's going to be in jail for a long time. A long, long time. A good guy, though. He was the first person that I met when I ended up there. And when I met this young man, he's the one that treated me with respect. I made sure he was helpful, gave me things when I first got there, made sure I was okay. I made sure I put $60 in his account before I left to make sure he understood how much I appreciated the fact that he went out of his way to be nice. He didn't have to. And the thing is, he didn't even speak English. That's how bad it was. But he took the time to say, you know what, I'm going to help you out. And so I made sure of that. All right, ladies and gentlemen, end of the video. I got less than 30 seconds, well, less than 40 seconds. I just wanted to say again, thank you all for the contributions. I am 50% of the way there. So in less than 2.5 weeks, I'm 50% of the way there. So I thank you. I got less than 2.5 weeks to go and less than 2 weeks to go. And so I'm hoping to get as close as possible. So thank you, thank you, thank you, those of you who have donated, and especially some of you who I've sent out thank yous to. You know who you is. Thank you. I can't thank all of you enough. but I can't thank all of you at the same time because it's too many of you. So, but thank you, thank you, thank you, thank you, thank you. Ladies and gentlemen, I hope this information finds you well. I hope it benefits you. Have a good day.